Good afternoon and welcome to the Employees' Choice Awards webinar series. My name is Susan Blaine. I'm Vice President of Ottawa Business Events, which is a partnership between the Ottawa Chamber of Commerce and the Ottawa Business Journal. And Ottawa Business Events produces close to about 45 business events every year, including the Employees' Choice Awards that are held at the end of January. Some of the other events that we produce are 40 Under 40 Awards, Ottawa's biggest office Christmas party, which is coming up in December, which is a great event. The Employees' Choice Awards, which are held, again, as I said, at the end of January, we honor and recognize Ottawa's top employees. The top Employees' Choice winners. And the Employees' Choice Awards are an award program based on real survey results. What companies do is companies engage their employees in an internal anonymous survey, and it takes about 2 minutes to sign up and about 10 minutes to complete. And then in January, we host a private morning event for all the companies who participated in the survey. We hand out the survey, we discuss the results, and more specifically, we discuss how to interpret the results. And Steve will be joining us for that as well. And we put them to use in our organizations. The top 10 companies will be published in the Ottawa Business Journal newspaper and then invited to a celebratory cocktail event where trophies are presented at the end of January. And companies honored in this ECA program that we've been doing for about 10 years now, they show some common trends. They clearly communicate realistic and achievable goals, and they celebrate achievements, doesn't matter how big or small, within the organization, and their employees are happy and engaged. So this particular ECA webinar series that we're hosting today and have hosted this month brings some of the region's most effective thought leaders together to share their insights and provide some tools that will help to hopefully empower you and your team. And today's guest speaker is Steve Levitt, and Steve is a partner and leader of the Employment Law Group at Nelligan O'Brien Payne. Steve has an extensive experience representing employee and employer clients in both private and public sectors. Steve frequently acts for clients in all aspects of dispute resolution, including mediation, negotiation, and representation before courts and tribunals. He has appeared regularly before both the Ontario Supreme Court and the Federal Court. He has acted in a number of class action proceedings and the professional regulatory litigation. He has been involved in complex insolvency matters, including acting as court-appointed representative counsel for employee groups. For Steve, the most rewarding aspect of his work, as he shares with us at Nelligan, is giving people and employers practical advice and establishing a roadmap to resolve their issues. He recognizes that the law profession is not just concerned with litigation, but also about finding solutions for problems at hand. And we're very pleased to have Steve with us here today. Steve's talking about a very important and relevant topic, the workplace in the social media age. Welcome, Steve. Thanks for being here.
Thank you, Susan, and thank you for that great introduction. So my topic today is workplace challenges in the social media age. As you can all imagine, it's a very complex issue, and that's one that's constantly changing. I mean, every single day I think there's a new form or new medium in which individuals are interacting through social media. So this is a very sort of new area of the law. The law is in many respects slow and hasn't really caught up to the realities of the workplace, so we're still sort of working through where this is going to go. But I'd like to sort of talk to you a little bit about today about some of those challenges and what we can do to address them based on what we know at this point in time, and perhaps maybe get in place practices and policies that can help us sort these out as issues develop over time. So just a brief overview of what I'd like to try to cover today, and there's a lot to cover, and I'll try to do it in the most efficient manner possible. And if people do have questions, like Susan mentioned, I think you can type in the messages, and I type in a message to me, and I'll try to address them as I go through as much as possible, and I'll try to leave as much time so that we can have a Q&A, and maybe Susan can tweak me in case if I'm going a little long, and let me know, because I do want to leave time for that Q&A at the end. So essentially what I'm trying to try to cover today is, first off, let's just do a little bit of survey. What actually is out there in terms of social media? And that's something that I said is changing. I mean, just in the last few weeks, for example, there's been a couple of new social media platforms or websites that have been created. So that's obviously an evolving issue. There are significant privacy issues that are involved in this new online connected world that we're all in. It also leads into how does our online and off-duty conduct affect our employment relationships vis-a-vis the employer and also our employees. How do we relate with them through these online vehicles and mediums? And of course, there's a dimension in terms of hiring in the social media age. We now often know a lot more or can know a lot more about employees than we ever would have known in the past just by simply looking up a person on Google or on their Facebook pages. And of course, you know, there's always the things that we need to do to address this in terms of workplace policies. So first off, let's just do a brief survey of what's out there, and I've listed a little bit of this on the slide. Obviously, the big one, or the 800-pound gorilla, is Facebook. I mean, Facebook is pervasive. It's very rare for someone in Canada, at least. I think Canada has one of the highest penetrations of Facebook usage in the world. For an employee to not be on Facebook. We also have LinkedIn. Obviously, LinkedIn, as we all know, is a little bit more professionally focused. Of course, there are other things out there like Twitter. Twitter we hear a lot about. Doesn't have as much penetration as Facebook, but still a very popular medium. But of course, we can't just think about social media platforms. We also have to think about things like YouTube and blogs, and even things like that are constantly evolving, like Reddit and Dig. And like I said, there was even a new one that was created just a few weeks ago that's sort of picking up speed called Ello. And what's interesting about Ello is apparently you can do it without having to use your actual identity, as opposed to historically for sites like Facebook, you had to actually identify who you were. And things obviously are changing and ever evolving. So for example, we're seeing a lot more what I'd call anonymous, and I put that in quotation marks, anonymous social media, whereby employees will use vehicles like apps that are called such as Secret or Whisper, where they will divulge anonymously information about what's happening in their workplace. So things are constantly changing, and we even have there are even some businesses now that have somehow decided to use Snapchat, for example, to send information, which may also result in creating some difficulties down the line. So, and of course, when you're looking at all these websites, they all have varying levels of public accessibility, and to some extent will depend upon the user setting out their, delineating what settings they have. For example, in Facebook, how much access do they give to people that are outside of their so-called friend networks. And so just on this slide, I'm just talking about what Facebook's all about. It's about to connect everybody in the open world. Of course, that means that everybody gets to know what everybody else is doing. And depending upon how someone has set up their privacy controls, there may be an illusion that, at least for the point of view of the user, that they've actually locked down their content when it may not be as locked down as much as they think. So there's problems of obviously delineating who the audience is that you're going to get your posts on. And that can potentially cause workplace issues, if somebody's posting about some sensitive workplace issues or commenting on their employer or their fellow colleagues. The reality, though, is this is something that we're going to have to obviously increasingly address as we go through this, what I'll call this new social workplace. It's a safe bet that most of your employees and probably yourselves are fully engaged in social media activities. It's definitely a reality, and a result it raises significant new issues and concerns. And really what we have to, and what I think the law is going to be grappling with over the next few years, is the reasonable balance that has to be struck between business and personal use. Unfortunately, the law being slow hasn't really completely caught up to this interconnected world. We're starting to see decisions that are being applied. Mostly they're coming from the arbitral world, which is generally dealing with unionized workplaces, so they don't necessarily aren't completely 100% analogous to non-unionized workplaces, but it's starting to give us some guideposts to help us to sort out what these issues will be and how we balance the social media use between business and personal use. So The reality, though, is this is not an issue that's going to go away. If anything, it's going to increase. I mean, here are some statistics. So we can see that the need for connectivity is increasing. At least 89% of enterprises are using the internet. I'm actually surprised it's that low. I would have thought it was higher. But in any event, so most of us are completely engaged in the workplace. We're not working the traditional 9 to 5 anymore. We're expected to respond to correspondence or deal with issues outside of normal, what used to be historically called normal working hours. And so there's an increasing need for both employers and employees to stay digitally in touch with the world, which of course will then trigger these issues that we're going to have to talk about. And that's what this next slide starts going into. So there's been a blurring of what I'd call the work and personal time. There is a sense that people are expected to be connected 24/7, and it's not just to work, but it's to work, but also to friends and family. So, and this is leading to a whole bunch of other issues, which will include dealing with what I call the BYOD movement, which is bring your own device movement to work, whereas people are now requesting more, at least employees are requesting more and more that they be able to use one device as opposed to having a separate cell phone or BlackBerry for work and then an iPhone for their own personal. They all want to combine it on one device. Of course, there's benefits to that because they're only carrying one device, but there are also risks in the sense that if there's the possibility of the employer information being mixed with personal information, and then where do we delineate the boundaries in terms of how an employer can access devices where an employee has used it for both personal and work purposes. Of course, there are some advantages to being in this interconnected world. One of them being there's the possibility of increased productivity because people are always accessible, so to speak, right? And that's one of the advantages. And we're seeing also a growing movement leading to what I'd call telework or working from home. And some research has shown that there's actually a 13% increase in productivity. This comes from Stanford. When people work from home, the research seems to show that there's higher employee satisfaction. There's also less turnaround. And of course, from the employee perspective, they have significantly less commuting time, which means they can actually spend some of the time they would historically commute to actually working. I don't know about you, but I have to drive into downtown Ottawa every morning, and at least takes me about 45 minutes. So working from home, we could actually recover that 45 minutes and be able to spend on work time. Now, the difficulty is, though, is that the law hasn't really completely recognized this sort of movement from working in the home or outside of the workplace to what historically we'd all come into offices and work in offices. So when you look at the Employment Standards Act, for example, it still sort of works on the premise of somebody working in an office with an employer who's tracking their time, tracking their hours for purposes of overtime, breaks, and the various vacation leave. So there's a bit of a disconnect between the way we're sort of working in the reality versus what the law sort of says. So the key point, though, is the same law still applies. And so to the extent that you have employees that are working off-site, you still need to keep track of their hours because the Employment Standards Act applies to them even though they are obviously working remotely or off-site. Now, traditionally, there used to be significant concerns when it came to teleworking. People were always skeptical of it, and for the biggest skeptical issue being what I'd call time theft, which is, you're not able to see your employees. So how do you know that they're actually working on their projects as opposed to doing other chores around the home or being out and about, going to appointments and et cetera. So there's always this theory, or at least this fear of there being potentially lower productivity. Of course, there are also other issues, and like if you can't supervise your employee, how do you know if they're doing something inappropriate or visiting some illegal sites? And the research tends to show, though, that actually, and like I mentioned a few minutes ago, that there's actually increased productivity with working off-site. So the traditional concerns don't seem to be completely borne out when looking at the actual data when it comes to looking at teleworking arrangements. However, we still have to make sure that any arrangement that we do put in place is monitored appropriately because there are new worries that are being developed as people work increasingly online or remotely. So if we're seeing, for example, issues dealing with cyberbullying and harassment, so individuals would be posting on, for example, social media websites making derogatory comments about their fellow employees. Similarly, we're starting to see issues around postings that are affecting an employer's reputation. So, for example, someone posting on a website saying, oh, you know, working at Walmart is not a bed of roses. Things of that type of nature, which could be detrimental, particularly depending upon the profile of the employer and the medium that these posts are being made of. Of course, the fact that we're all working remotely or electronically leads to the possibility or an easier possibility of disclosure of proprietary and confidential information, because it's the ability to access information remotely also means it's obviously easier to share. And there are also issues revolving around cyber sabotage, malware, and hacking. So, for example, we have to be more vigilant in terms, because people are actually accessing our networks from outside or external sources. We have to be more vigilant and ensure that however they're accessing our systems, is secure, and that data or information isn't being leaked out inappropriately. So these concerns all need to be addressed, and the biggest one, though, I think is, and the one that the law is really grappling with, is privacy concerns. So, you know, how do we deal with the privacy issues when the employers are increasingly providing platforms such as computers or smartphones for the employees' use, or on the other hand, some employers utilizing bring your own devices where the employees actually go out and buy it, and the employer subsidizes usually a part of the cell phone plan, and which means that these employees are increasingly using the devices not only for work-related and personal reasons, and as a result there's a commingling or an intermingling of work and privacy issues. And the traditional or the sort of traditional viewpoint of the law was, well, if it's happening in the employer's workplace and the employer owns the equipment, and that would mean, therefore, that everything on the device is the employer's property. But that view seems to be too strong. The law seems to be trying, as it usually does, looking at things in a contextual manner and trying to balance between the employer's interest and the employee's rights to privacy. So, for example, you know, the law historically would have seen if I had, if I was using an employer's email system to send emails, that the employer would have a complete right, because they owned the system under which that the emails are sent out on, that the employer would have the complete right to be able to have access to those emails. However, more recent case law seems to be balancing those interests. And I guess that's not completely a surprise. So, for example, if we tried to move away from this online world and thought about it from the perspective of a physical object. So, for example, the employer, you're working in an employer's office. You obviously have a desk, and on your desk is someone's purse or bag. Now, historically, some people would have said, well, you know, the employer owns the desk, and therefore they could go access to it at any time. However, you know, we wouldn't expect it reasonable for an employer to be able to go in there and open up your purse or your bag and go right through your records, even though it's an object that's physically on the employer's premises. So there's always been a reasonable expectation of privacy, and it's now sort of extending that privacy to this online world where the delineations between what I'll call the employer work and the private nature of the usage of the device isn't always 100% clear. And so that's the thing. That's what's starting to be grappled with, right? So the early years, like this slide sort of indicates, the original sort of decisions or case law around it was that there was very limited or no electronic privacy rights. So if you sent an email on your employer's system, even if it was using Hotmail or Gmail, for example, the original decisions or early decisions would have said you had no reasonable expectation in the employer in the workplace because the device belonged to the employer, the employer allowed to access or could easily access these communications, and generally speaking, managerial rights provided that that an employer was entitled to supervise the employee's use of their devices. And so the reality is those initial cases were pretty broad and not very, didn't recognize any expectation of privacy. So, for example, there were cases involving situations where an email would be sent from someone's personal Hotmail account. It would have personal information in it, and the case law the decisions would be that, sorry, even though the information was sent from a personal Hotmail account, well, accessed from an employer's laptop, the employer still had the right to get to the substance of those emails. And so that was what the sort of law was looking like, where it was going towards, and it seemed to be that the response would have been that all an employer really had to do was make it clear that they owned the device that was being used, and set out a policy that specifically said that they had the right to review any usage of their electronic devices. However, that seemed to have changed slightly in 2012 in its decision of the Supreme Court called R v. Cole. Now, R v. Cole was actually a criminal case, and so it commented on employer and employee rights, but it was actually in the context of this criminal case that involved a high school teacher's charter rights. And the issue in that case was whether or not this high school teacher's charter rights were breached when the police searched through a laptop without a court-ordered warrant. So in this case, what had happened was that the laptop had been provided to the teacher by the school board for teaching purposes and for monitoring students' computer use. And the school had also permitted the teachers in question, including Mr. Cole, to use the laptop for personal purposes. So there was a clear understanding that Mr. Cole was entitled to also use it for personal purposes. Now, in the course of monitoring data stored on the students' computers, Mr. Cole copied some nude photographs of a student from her personal email account. Subsequently after that, an IT person who was working for the school board discovered the photographs while he was doing a routine virus scan and maintenance of Mr. Cole's hard drive. Now, the technician notified the school principal, who instructed him immediately to copy the photographs onto a CD. The principal then seized the laptop, handed it the CD, and a copy of Cole's temporary internet files, which included the history of what he had been looking on the web, that history contained pornographic images. And he handed that all over to the police. The police then reviewed the context of all those, the laptop, the CD, and the temporary internet files, and without a warrant, charged Mr. Cole because of the photograph of the student with the possession of child pornography. So what was interesting about this case is the court had to grapple with sort of the two searches. First, it sort of looked at the school search, whether what the principal and the IT person was, whether or not that was reasonable in the circumstances, and secondly, had to look at whether or not the ensuing police search of the computers was legal. Now, schools are obviously operating in a bit of a different context. There are statutory obligations for school boards and teachers and principals to maintain a safe school environment, and so ultimately the court ruled that the school board was legally entitled to search Mr. Cole's laptop and to seize the materials that were on it. However, the court said that the principal did not have the right to consent to a warrantless police search of the computer, even though the school owned the computer. And the court said that was the case because it found that, and here's the key part, that Mr. Cole had a reasonable expectation of privacy in the personal information he stored on the school's laptop, right? And so ultimately, because there was an element of allowed personal use, it was reasonable for him to expect that he'd have some privacy in that personal information. And the court went on to sort of say that whether the reasonable expectation of privacy of an employee will apply in the particular circumstances will depend on the totality of the circumstances that are being under review. So what they did make clear is that it wasn't sufficient to just say that the employer owned the device. That's not a complete answer to the employee taking the position that they have an expectation of privacy, nor was it enough to just have a policy. You have to look at the entire context, including how the devices were used in the particular workplace. So this has meant that things are now going to start to develop in the employment field, and we're starting to see a little bit more in terms of decisions. So not too far after R.V. Cole, we have a decision in what's called R.V. Barbo, which is listed on the bottom. Again, in this case, this involved a former employee, and what was interesting about this case is even though the person was no longer employed and had left the employer 3 years earlier, and during the course of leaving the employer's employment was provided with a laptop and told you can keep it, do with it what you want, and for whatever reason, 3 years later, he brought it back to the employer for some scheduled maintenance. And even in that circumstance, they discovered some child pornography, and the employer then turned it around and gave it immediately to the police. But the court found that this was a breach of Mr. Barbo's charter rights because even though he was no longer employed, he still had an expectation of privacy. So all that meant is that the police, in both cases, R.V. Cole and R.V. Barbo, had to go out and get a search warrant before they could actually take a look at the respective computers. But what it does mean is that in terms of the employment context is that we have to be cognizant of the fact that employees do have these reasonable expectations of privacy, particularly where there is a mixed use of devices. And so we can see this in a couple of other cases that have flowed and are very recent. We've got one decision here called New Brunswick versus CUPE, 2004. Now it's a unionized case, but in this case, the arbitrator held, and the court upheld this decision, that personal emails sent by an employee from her work account to her partner, even though they contained foul, really foul, I won't repeat what the language was, but pretty bad language, and as well as revealing photos that were clearly personal, and she used it. She wasn't using a Hotmail account or a Gmail account. She was actually using her work email account. And the dismissal still couldn't be justified. And this also came in the context where the employer had an actual policy which stated that the user would not create, access, store, publish, or send any files through Workplace that were considered to be unlawful, obscene, pornographic, et cetera, et cetera. So even though in this case the employer had a clear policy and the employee was using the actual workplace email, it still wasn't enough to justify the employee's dismissal. And the arbitrator ultimately said the policy was too broadly worded, and it didn't clearly define the degree of privacy which an employee may expect when using their work email for personal use. So I guess the key take-home message from that case is you've got to make sure that the policy, if you're going to have one, clearly delineates what the boundary is between privacy expectations and work expectations when it comes to computers. But keep in mind, though, you can still have the best policy drafted, but it still has to also conform with the way the employment relationship actually happens on the ground. So your policies have to reflect the actual reality of the usage of the devices. And then even in which is really interesting in this later case, Transatlantic Corp, this was involving an investigation of a company by a regulatory body. So the regulatory body in Alberta was investigating some issues that involved around Transatlantic Corporation's own obligations under a statute. And as part of that regulatory investigation, they wanted to get some documents on an employer's computer, but the employee who had been using the computer in question claimed that they were actually personal. And at the outset, the judge, the Chambers judge, found, well, there can't be any reasonable expectation of privacy, particularly given the context of this regulatory body searching it. And it went up to the Court of Appeal, and the Court of Appeal said no. In light of the decision of the Supreme Court in Cole, the employee's claim to reasonable protection of privacy can't be summarily dismissed. You actually have to look at the documents, and you have to look at what they say and what they're being used upon in order for you actually address before the issue is actually dealt with. You can't just say, nope, no expectation of privacy, it's an employer's computer, it's in the context of a regulatory investigation, it has to be disclosed. You actually have to do an analysis of what that reasonable expectation of privacy, and as the Supreme Court said in Cole, it's going to depend on the totality of the circumstances, whether that expectation will trump the ability to get access to the information or use it. So we're still, these are two recent decisions. RV Cole is only a 2012 decision, and at this point, the law is still developing, but what appears to be clear is that there is at least some expectation of privacy on the part of employers when they're using workplace devices. And what we're going to need to do to address these matters forward is to make sure that expectations are communicated very clearly to employees, particularly if the employer wants to reserve the ability to be able to supervise and which I suggest you do, supervise the conduct of employees while they're using your devices. Now, there's also been a couple of other developments which are interesting, and one of them is, as the law slowly develops, it is recognizing a new tort of what's called intrusion upon seclusion, and this basically really means it's a new tort dealing with potential breaches of privacy. So it's not only that we have to deal with employees and what their rights are in terms of privacy, but we may also have to, and we do have to think about, okay, if how are our employees using information, and whether or not, if they're inappropriately accessing or disclosing information, does that attract liability on a part of the employer? And there is one so far decision that deals, and it's called Jones v. Teague, which is at the top of the slide, and that involves a situation where on 174 occasions, one bank employee accessed the personal financial records of her coworker, and it involved, it's a very convoluted fact scenario, but essentially the Sieg was in a relationship with a person that also previously been in a relationship with Jones, and she was trying to find out more financial information vis-a-vis her ex-spouse by accessing Jones's account to see if they were making he was making some payments. But the net result is that on 174 separate occasions, some fellow employees' privacy was breached, and as a result, the court decided that they had to create a new tort. And the reality is, this means that if an employee is accessing information that's private of another person intentionally, and they're doing so without any justification, and ultimately the court concludes that the access can be regarded as offensive, there could be personal liability not only on the employee that's accessing the information, but the employer as well. Now, in this case, the award was relatively modest. It was only $10,000, but that was because the employee whose information was breached wasn't able to show that she suffered any real pecuniary loss. You can imagine a circumstance whereby if someone was improperly accessing or using private information, and they then in turn caused some financial loss. So, for example, let's say a case of identity theft, that those damages could increase significantly. And so the key point to take out here is that the employer can be liable vicariously for improper access by employees. The other thing that we're starting to see is significant issues dealing with harmful online comments. So, and how do we grapple with those issues? So, for example, there are cases that are developing dealing with situations where an employee will make harmful comments against a fellow colleague. They'll post these comments on Facebook, for example, and the audience to those comments can be mixed. So, for example, often employees will have friends that are coworkers on their Facebook. So obviously the information of the derogatory comments are actually being exposed to fellow coworkers, which can have the effect of potentially poisoning the workplace. So some of the considerations that apply when we're dealing with this type of stuff is, well, number one, is it off duty? Usually, is it happening after hours? But even if it's off duty, is the conduct still work related? In other words, is there still a material connection to the workplace? How broad is the audience? Has the person limited it to their friends? Are the people that are their friends, and do they include coworkers? Is it more than harmful shop floor talk? Is the nature of the post, is it a permanent online record? So, for example, if somebody's posting on a public blog, as you may or may not know, it's fairly difficult to delete things. Even if you delete stuff, Google tends to index the web, and so technically speaking, it's available through archives. So is it a permanent online record? So, for example, has an employee gone out there, or a former employee gone out there and made derogatory comments of the employer and in a public forum, and how do we deal with those types of issues, right? And so that's what the courts have been grappling. So, for example, and we're also seeing cases whereby individuals are posting videos of or uploading pictures of stuff that's happening in the workplace, which may be violent. So the case here that's referred to in the bottom of Simard and Westlink versus Wallace is an interesting case where this employer became aware of 93 separate video and audio recordings that were posted on a YouTube website by, it appears to be one of their employees, and it was pictures of and videos of employees with alcohol at social events, and also doing damage to some of the equipment. Now, the videos were posted anonymously, so it was difficult to see who or determine who had been posting these things. And so the court, what the court ultimately grappled with was whether or not those videos could be ordered to be removed, and ultimately the court did grant a declaration and a permanent injunction removing them. But we're seeing here is that this is an example of an employee posting information to YouTube, and which arguably could be a permanent online issue, and obviously very damaging to the employer's workplace. So how have courts dealt with this type of stuff? Well, mostly it's been, so far to date, dealing with arbitral decisions in the unionized context. We don't have a lot of, at least to date, employment non-unionized decisions. However, what they're looking at is, what are the nature of the comments? Do they adversely affect the employer's legitimate business interest and reputation? If the comments are sufficiently abhorrent or vile, often the arbitrators are assuming that harm can be presumed. There's also the issue of investigating whether or not the comments are derogatory or threatening about coworkers or supervisors, and they'll also be particularly troubling if there are derogatory comments regarding clients. If your clients, for example, are in a demographic that is also vulnerable to discrimination. So, for example, natives or elderly people. And so courts have been grappling this. For example, in one decision in Compo versus Yellow Quill First Nation, the employee made postings attacking the credibility of her supervisor and her standing in the community, and this was an Aboriginal individual in the Aboriginal community. And the arbitrator found that they were particularly harmful because working in an Aboriginal community, the postings were viewed by members of the band, and ultimately what the employee had done had not only made it impossible for any working relationship to ever be repaired with the supervisor, she had also damaged the employer and the supervisor's reputation in the community, and therefore the dismissal for making those postings was upheld. Similarly, there's a decision in dealing with in Chatham and Kent, dealing with where an arbitrator upheld the discharge of a personal caregiver at a home for the elderly when she created a blog post in which she posted disparaging comments and pictures about the residents, fellow workers, and their management. So you know, so we're starting to see that these postings can be cause for dismissal, particularly where they are damaging to either the legitimate business interest and reputation of the employer, and if they are derogatory or threatening to coworkers or supervisors. The other thing to keep in mind in all of this is that there is a right to a harassment-free workplace, and that obviously underpins some of these decisions. So, for example, as you all, I'm sure, are aware of, under the Occupational Health and Safety Act, there is a legislated duty to provide a workplace free from violence and harassment, and that includes domestic violence, which could lead to injury of a worker in the workplace. So the net effect of that legislation means that if the employer becomes aware of these what I'll call online bullying or harassment comments, we can't ignore them. We actually have to take them into account and take the appropriate steps. And that also would similarly apply to comments which would be discriminatory. So, for example, postings that would denigrate someone's religious or racial background. So these are things that we're going to have.
You, Steve.
Oh, okay. Sorry. I'm going long, am I?
No, this is fascinating, and I've got a few questions, and I wonder if
sure.
we're, at this point, if it makes sense, or are you soon wrapping up? Did you want to open it up for some questions? I know you're sharing a lot of examples here. Oh,
no, and you know what? That's good. That's perfectly fine. Let's certainly go ahead with some Q&A, because there is a lot of material to cover, and if anybody wants it, I'd be happy to provide the rest of the PowerPoint. Oh, wow, that's great. We can send that around following Absolutely. This presentation to everyone that registered. Just trying to be mindful of the time. Sure. And, you know, there's some questions that certainly popped up for me. Maybe I can kickstart it. Sure. Maybe we could open it up for those of you that are listening in today that have joined us. You can type a message in on the right-hand side of your screen. You can type in a question, and I know Steve would be happy to answer it. I've got a couple of my own that maybe I'll start off with, Steve. You know, there's a lot of examples here, and of course social media is so prevalent these days, and what should an employer then do when they learn that an employee is publishing derogatory material about the workplace through social media? What actions do they take? Well, I think the first thing you're going to have to do is obviously investigate the matter. You don't want to jump to conclusions. So the first thing you would do is if you can, get a copy of what the postings are so that you can see what the actual comments are, and then determine whether or not and this is the tricky part, whether the online activities are materially related to your workplace or enterprise, right? So, so for example, you know, if I post it on Facebook and it casts the employer in a bad light, but it doesn't really do serious or lasting harm. So I'm going to say, I'll use the working at Walmart ain't all exactly roses. That may warrant a warning, for example, and say don't do it again. But that's not one where you would jump all over and say, you know, you've destroyed our reputation. You're never going to be, our legitimate business reputation and interests are damaged, and you can't work here any further, right? I think you have to look at sort of the substance of the context. At the comments, and sort of determine what's appropriate in the circumstance. But I mean, step one would be to obviously take a look at what the comments are, try to determine what the impact is on the employer's legitimate workplace interests. And of course, if there's another dimension, if the comments are harassing or threatening violence against an employee, then we're going to have to obviously take more extreme steps depending on the nature of what's being said. The key, though, I think is, and part of this, I think, obviously, is an ounce of prevention. Yes. And so one of the things that I think good employers will do is have detailed policies on social media and their technology, usage of their device, so that they make sure that the employees are aware of what is appropriate and what isn't appropriate, like what would be a permitted use and what isn't a permitted use, and what the employers are sort of expecting from their employees as they represent them out there in the wider world. So you were saying regarding the
The present Occupational Health and Safety Act, you know, that we should, to some degree, as employers, monitor employee social media. I guess how much online monitoring of employee social media is appropriate?
That's a good question, and it's a difficult. That's going to be a difficult balancing act because obviously we can't force employees to be our friends on Facebook, so to speak. So I don't think any employer should have a policy that for example, forces an employee to be a friend of them or follow them on Twitter or whatever. But to the extent that the employees have, you know, friended fellow colleagues or followed fellow colleagues, and those sort of postings come to light to the employer, and then I think there's a positive obligation to look into the issues.
Yeah, that makes sense. Is there, back to something more positive,
Yeah.
What is the sort of appropriate way to get employees involved in the company's social media, like advertising efforts? So for example, when an employee has a Facebook page or a Twitter account, what is the appropriate role for the employees to play in promotion?
Yeah, and you're quite right. I mean, there is an appropriate role, and obviously, as we know, it can be an effective advertising tool to have your employees engaged in your social media campaigns, particularly when they can be your greatest resource because they'll know people and it can obviously extend your reach significantly. I think the key is going to be, well, part of it's going to depend upon obviously the nature of the business. You know, so for example, if an employee is working at a factory and they are, you know, helping you to create your widgets, well, probably there's less of a role for that person to be involved in your social media campaign. Whereas if an employee is involved in what I'll call a more public-facing role, there's more of a role for that employee to play. I think the key would be to have to give the employee guidance with respect to what the expected behavior would be in relation to your workplace and what you would expect them to do online. I kind of want to use the word code of conduct, which would describe what would and would not be acceptable for them to help you out with in terms of online communications.
So the code of conduct, so is that something that your firm would help a company create, sort of a code of conduct?
Yeah, we would help. We often do and can help employers deal with creating social media policies and codes of conduct. And I think a lot of it comes down to common sense.
Yeah.
And ultimately, at the end of the day, I think what you'd want to tell the employees, if they're not sure about something, like how do we do this, talk to you first.
Yeah.
But you know that also leads to sort of an interesting thing that I don't think the law has really, as far as I know, hasn't grappled at all yet in Canada. But I'm aware of at least one decision in the U.S., and that's what happens when, for example, we have employees that are in marketing or sales-related roles, and their job, what if part of their job is to create these sort of social network media connections?
Yeah.
And if they're using personal vehicles to do that, who then owns the Twitter followers, for example? Mm-hmm. That's not something that the law has really grappled with in Canada, but it may be something that I think forward-thinking employers may want to think about before they enter this. Because last thing you know, the last thing you want to happen is, let's say you've got, you know, an employee that's been with you for 5 years. They've generated this huge list of Twitter followers or Facebook followers that you're using to market to, and that individual, for whatever reason, ends its relationship, takes those followers with them. So how do we deal with those types of things? Those are things I think employers are going to have to start thinking about up front, perhaps even addressing them up front in contracts. That
makes a lot of sense.
Mm-hmm.
I see an amendment I need to make right now. Well, this has been great, Stephen. I'm sure we could carry on for a couple of hours. I'm sure you have a lot of contact, and it's so generous of you to offer to provide these slides to our listeners today. We'll certainly connect with you to do that and send out an email. And your contact information, if that would be okay.
Absolutely.
For them to reach out if they have any additional questions that we weren't able to get to today. Thank you so much for your time. We appreciate it. And we'll send that email out to everyone that's on the call. And we have one more great seminar remaining in our series next week. We hope that you'll join us at your desk again next Wednesday, October 22nd, from 12 to 12:45 with Michael Horn, and Michael's with Meldrum Horn and Associates, and he'll talk about the top benefit trends for 2014. So we hope you join us for that. And now, if you're interested in learning more about the Employees Choice Awards program that we talked about earlier, please visit employeeschoice.ca. And if you want to get your company involved with the survey, remember it only takes 2 minutes to register and about 10 minutes to complete. And here's what we know for sure about companies who have engaged employees. Organizations with engaged employees get better results, they're more productive, they have less turnover, they're more innovative, and engaged employees are happier, healthier, and they're stronger contributors to the organization, to their family, and to their communities. Before we leave you today, I just want to please quickly thank our dedicated partners that have been with us for many years, including our speaker today, Nelligan O'Brien Payne, our partner Talent Map. Thanks again to them. They do the surveys and have for over a decade with us. Our lead sponsor, Nelligan O'Brien Payne, Meldrum Horn and Associates, Career Joy, and the HRPA, Human Resource Professionals Association of Ottawa. They've been our partners for many years. We thank you. Thank you for joining us today. We hope that you've enjoyed today's webinar and that you join us next week. Thanks again, Steve.
Thank you very much.
Have a wonderful day, everyone. Bye-bye.
Bye-bye.